Introduction. The CMSA requires certain persons engaged in the capital market to be licensed for the purpose of protecting potential investors and maintaining appropriate standards. The intermediaries that need to be licensed are those who carry on the regulated activities prescribed in the CMSA as well as their representative. Topics objectives are: explains who requires a license, describe the requirements to be met by license holders, list the continuing obligations of license holders, list the consequences of dealing or advising without a license, and lastly list the requirements of the rules of Bursa Malaysia Security Berhad in relation to a holder of a capital market service representative license for dealing in securities. 1.1 Regulated Activities. Section 58 Clause 1 of the CMSA set out that where a person is carrying on an activity which falls under the definition of regulated activity in Malaysia, that person is required to obtain the appropriate license in accordance to the process and procedures set out in the CMSA. Determining whether a particular activity falls within the definition of regulated activity under the CMSA is fundamental to the capital market licensing framework. Schedule 2 of the CMSA describes and defines the following categories of regulated activities. First, dealing in securities. Second, trading in future contracts. Third, fund management. Fourth, advising on corporate finance. 5, investment advice. 1.2 Single Licensing Framework. Prior to the CMSA, the SIA and the Future Industry Act 1983 regulated intermediaries in the securities and future industries respectively. Although generally licensing requirements were similar, there was still some difference in certain fit and proper requirement for intermediaries. The CMSA addressed the situation through Section 58 of the CMSA. The section sets out the general requirements for a person carrying on any regulated activities to hold a capital market service license or CMSL. The CMSA also standardized the fit and proper requirements applicable to all license holders under the CMSA, while specific requirements relating to individual types of license are set out in the licensing handbook.
Two-tier licensing framework. In the CMSA, the licensing framework involves a two-tier regular system, which is both the principal as well as the representative are required to be licensed. The two-tier framework is based on the principle that the CMSL holder is responsible for the activity of the representative. Therefore, need to ensure that they are on compliant with all the relevant rule, regulation and held accountable for their action. On the other hand, every application for CMSRL must be supported by the principal who is a holder of CMSL. The representative for CMSRL applies both to a person who is employed by a participant organisation. It refers as the salary or paid dealer representative, as well as the agent, generally referred to as the remission or commission dealer representative. Procedure for licensee application. In order to obtain a CMSL or CMSRL, application must comply with a requirement of the CMSA or any guidelines made under CMSA. Section 60 Bracket 1 of CMSA set out that application for license must be made by the SC in the form and manner prescribed by the SC, and license fee must be paid. All information and documents required by the SC must be provided. In education, the SC can notice the application for a license in writing, to submit detailed information or copy of document on issue related to the application. If a application gives false or misleading information, the application is liable to be rejected. In addition, if a application may have false or misleading information or material omission in connection with the license application, they are able to be fined up to 1 million or imprisonment up to. This one we can see in the section 71 of all information and document required by the SC must be provided. In addition, the SC can notice the application for a license in writing, to submit detailed information or copy of the document on issue related to the application. If a application gives the misleading information, the application is liable to be rejected. In addition, if an applicant made or misleading information or a material omission in connection with the license application, they are able to fine up to 1 million or imprisonment up to 5 years or both. This one we can see on section 71 of the CMSA.
1.5 Fit and proper criteria. In capital market throughout the world, intermediaries are mostly required to be authorized or licensed by a regulatory authority. This need arises to ensure and inculcate market participant and investor confidence that the organization and its respective individual whom they intercept are efficient and financially sound. 1.5.1 CMSA. The CMSA has streamlined the requirements relating to the fit and proper criteria that applicants for CMSL and CMSRL have to fulfill. The fit and proper criteria prescribe not only situations where the applicant has been convicted of an offence, but also situations which are not unlawful but where the applicant's action appear to the SC to be deceitful, oppressive, or improper. The CMSA empowers the SC in considering the fitness and propriety of a corporate applicant to refuse to grant a license in the event the directors, chief executive, managers, or controllers of the applicant are in breach of the criteria set out in Section 65, Clause 1 of the CMSA. Section 75, Clause 8 provides that the SC can direct the CMSL holder to remove its director or chief executive upon the SC becoming aware that the director or chief executive is not fit and proper. The fit and proper criteria for applicants of CMSL and representative. The criteria include conditions relating to probity, financial status, regulatory compliance, record of past performance, reputation, character, financial integrity and reliability, and last but not the least, public interest consideration. 1.5.2 Licensing Handbook. The Licensing Handbook has divided the fit and proper criteria for purpose of holding a CMSL and CMSRL into organizational requirements, shareholding composition, financial adequacy, and requirements relating to an applicant's competency.
1.6 Obligations of the licensed persons. Under the Capital Market and Services Act (CMSA), a licensed person has the following obligations: first, to notify the SC if there is a change in their particulars, no longer carrying on business or acting in the capacity, or no longer acting as a representative states in Section 78, which is notifications of change of particulars, where the holder of a CMSL chooses to carry on all of any of the regulated activities to which the license relates and chooses to be a representative of the CMSL holder, in relation to whom the Capital Market Services Representative License was issued. A change occurred in any information required to be entered in the register of license holder, and the holder of the license should, not later than 14 days after the occurrence of the events concerned, give to the Commission, in the specific form, particulars in writing of the events concerned. Second obligation is to notify the SC of an event for which the SC can revoke his or her license. In Section 74, states notifications of disqualifying events. A licensed person shall, immediately after the happening of an event that is a ground on which the Commission may revoke a license with, give to the Commission written notice setting out the particulars of the events. It also should be a defense for a licensed person who is required to give notice if it is proved that when the requirement arose the licensed person was unaware of the event that gave rise to the requirement. A person who contravenes subsections 1 commits an offense. Third of obligation is to keep a register of his or her interest in security and notify the SC as to where the register will be kept. This was stated in sections 83 and 84. In section 83, Register of Security, any person referred shall maintain a register in the specified firm of the securities in which he has an interest. The register required to be kept under this division shall be kept at such place within Malaysia as may be nominated by the person referred but for the purpose of this vision, provided that such person shall notify the Commission in writing of the beginning to keep the register. A person referred shall enter in the register particulars of the securities in which he has interest and particulars of his interest in those security within 7 days after the date of the acquisition. Where there is a change, not being a prescribed change in the interest in security of a person referred, he should enter in the register full particulars of the change, including the date of the change and the circumstances by reason of which the change has occurred, and the entry should be made within 7 days after the date of the change. Section 84, which is notice of particulars to commissions. Any person referred shall give notice to the Commission in such forms as may be specified, containing such information as may be specified, including the place at which he will keep the register of his interest in securities. The notice shall be given in the case of a person who is required by this Act to hold a license as part of his application for the license. In the case of any other persons, if the person becomes a person referred within 14 days from the date of his becoming such a person, the notice shall be so given, notwithstanding that the person has ceased to be a person referred before the expiration of the period referred. A person who ceases to be person referred shall give notice to the Commission of his ceasing in the specified form within 14 days of his so ceasing, and any person who fails to give notice as required by this section commits an offence. Fourth obligation is to make his or her register of interest in securities available for inspection by the SC or CCM. In Section 86, Production of Register, the Commission may require any persons referred to produce for inspection the register required to be kept pursuant to Section 83, and the Commission may make a copy of or make extract from the register. A person who fails to produce a register for inspection or fails to allow the commissions to make a copy of or make extract from the register commits an offence. Fifth of obligation is not to represent or imply that his or her abilities or qualification has been approved by the SC. Next, to disclose interest in securities in circulars where recommendations are made. This is stated in Section 89, which is certain representation prohibited. A licensed person shall not present or imply or knowingly permit to be represented or implied in any manner to another person that the abilities or qualifications of such licensed person have in any respect have approved by the commissions. A mere representation that a person is the holder of a capital market service license is not a contravention of these sections. And lastly, do not deal as principal without so informing his or her clients. In Section 97, dealings as principal, a holder of a capital market service license who carries on the business of dealing in securities shall not, as principal, deal in any security with a person who is not such a holder, unless the holder first informs such persons that the holder is acting in the transaction as principal and not as agents. A reference in this section to a holder of a capital market services license who carries on the business of dealing in securities as principal includes a reference to a person's dealing or entering into a transaction on behalf of a person associated with such holder, dealing in securities on behalf of a corporation in which it has a controlling interest, or where it carries on a business of dealing in securities on behalf of a corporation in which its interest and the interests of its directors together constitute a controlling interest. A holder of a capital market services license who carries on the business of dealing in security, who as principal deals in security with a person who is not just a holder shall state in the contract notes that the holder is acting in the transaction as principal and not as agent. Where a holder of a capital market service license who carries on the business of dealing in security contravenes subsection 1 or 3 is respect of a contract of the sale securities by the holder. The purchaser of the security may, if he has not disposed of them, rescind the contract by a notice of rescission in writing given to the holder not later than 14 days after the receipt of the contract notes or on becoming aware of the contraventions, or for a purchase of security by the holder, The vendor of the securities may rescind the contract by a notice of rescission in writing given to the holder not later than 14 days after the receipt of the contract notes or on becoming aware of the contravention, whichever is the latter. 1.7 License Conditions. The SC can grant a license under Section 62 of the CMSA subject to conditions or restrictions that it seems fit. In Section 62 states that power of Commission to impose conditions or restrictions on license without prejudice to Section 61. The Commission may at any time, where it deems necessary, vary the conditions or restrictions imposed upon the grant of a license or impose additional condition or restriction on a license, while the license is in force. 1.8 Variation. A CMSRL holder may apply to the SC to vary the name of his principal. The variation is subject to the SC's approval. In Section 69 of the CMSA, variation or transfer of license. Section 69(1) The Commission may, on the application of three which are: first, a holder of a capital market service license, vary its license by adding or removing a regulated activity to or from those already specified in the license. Second, a holder of a capital market service representative license, vary the name of his principal on whose behalf he may add the regulated activity to which the license relates. Or, a holder of a capital market service license transfer its license to any other person after the holder has obtained a court order. In Section 69(2), the Commission may require an applicant to supply the Commission with such information or document as it considers necessary in relation to the applications. Section 69(3). An application under subsection 1 shall be accompanied by a prescribed application fee which shall be paid in such manner as may be specified by the Commission. Section 69(4). The Commission may in two ways which are: first, approve the application subject to such condition or restriction as it deems fit. Second, refuse the application on any of the grounds set out in subsection 64(1) or 65(1), or on any other grounds as may be specified by the Commission. Section 69(5). The Commission shall not refuse an application under subsection 1 without giving the applicant an opportunity to be heard.
1.9 Revocation and suspension. Subsection 72 and 73 may apply to the CMSA and note the circumstances in which the SC can revoke a license. First, before revocation or suspensions, the license holder is given the opportunity to be heard. Second, in the event of winding up for a corporation or for an individual, in the event the individual is an undischarged bankrupt or has been convicted of an offense set out in Section 65, bracket 1, bracket G, bracket 1, or bracket 3. The SC may revoke or suspend the license without giving the licensed person an opportunity to be heard. Third, the SC may suspend the license instead of revoking the license if it considers it desirable to do so. 1.10 Effect of revocation or suspension. S.73 bracket 1 of the CMSA provides that a revocation or suspension a license shall not operate so as to First point, avoid or effect any agreement, transaction, or arrangement relating to the regulated activities entered into by such person, whether the agreement, transactions, or arrangement was entered into before or after the revocation, suspension, or expiry of the license, or the imposition of restriction on the license as the case may be. Second point, effect any right, obligation, or liability arising under any such agreement, transaction, or arrangement. As point 73, bracket 2 further prescribes that where any license is revoked or suspended, the SC may subject to such condition as it may specify in the notice, permit the CMSL holder to first case revocation, carry on business operation for the purpose of closing down the business connected with the revocation. Second case as suspension, carry on only essential business operation for the protection of the interest of client of the licensed person during the period of suspension. Third case of an expiry, carry on such business activity as the Commission may approve for the protection of the interests of clients of the person who held the CMSL before such expiry.
CMSRL for dealing in securities, which is dealer's representative. The rules of Bursa Malaysia Securities Berhad set out requirements as to dealer's representative. Rule 310 of the rules of Bursa Malaysia Securities Berhad and in particular are follow. A representative can only act for one participating organization. However, a dealer's representative can also act as a future broker's representative if he or she holds the appropriate license and there is an arrangement satisfactory to the exchange as to proper supervision of the dealer's representative activities. A dealer's representative must be duly registered by Bursa Malaysia Securities Berhad in the manner provided by the rules of Bursa Malaysia Securities Berhad, and no participating organization shall employ a dealer's representative unless the dealer's representative is registered with Bursa Malaysia Securities Berhad. Next, to be duly registered with Bursa Malaysia Securities Berhad, a dealer's representative must hold a valid CSMRL for dealing in securities. A dealer's representative must be engaged full-time and there are various prohibitions as to his or her activities and interests. If a dealer's representative employment ceases, a notice must be given to Bursa Malaysia Securities Berhad and the Commission within 14 days after such cessation. Rule 404.4 Clause 6 Clause A provided that a dealer's representative can only open an account opening form in person. However, Rule 404.4 Clause 7 set out exception to Rule 404.4 Clause 6 Clause A for situations where the dealer's representative is allowed to open an account for client without the client executing the prescribed form in person. Therefore, a representative is liable for losses due to his or her default. A participating organization must have an adequate system of supervision in relation to representative. The commission of a remisier, which is commission dealer's representative, shall be fully negotiable between the participating organization and him. All participating organizations and their commission dealers representative must enter into an agreement to govern their relationship according to the principle prescribed by Bursa Malaysia Securities Berhad.
A remiser must not share his or her commission with any person other than his participating organization and or any other dealer's representative employed and engaged by the first mentioned dealer's representative participating organization.